I normally wouldn't have as much a concern there, but since we have no idea which timeline between this and any of the other applicants that will be developing in here, I think it needs to be before construction.
Okay.
That's my opinion.
I agree.
And are you guys looking at potentially just around this actual commercial, or are we going to be asking?
I mean along the residential homes that are off Albert Court and Carolyn Court.
Okay.
So the property that was in the original subdivision application that created this lot.
Yeah, I
Does
think
that make sense to staff?
Yes.
What were you gonna say, Kurt?
Well, because that's typically what we do is we require that along all of that residential. So I think that this is a spot where we've got missing fences.
And that's kind of why I think we're to the point where it needs to be tied to the construction of anything, is because it seems like we're just not getting it done, and we need to get it done. Are you related?
Are you
to
the
this?
applicant? No, I live right there. Okay, this isn't a public hearing right now, so if you want to, after the meeting, you can talk with one of the city staff and they can help address any questions you may have. Applicant? I addressed that. Sure, come on up.
We understand the request of the city as far as the concrete cast wall that you want to have on the lot next to ours, basically is what you're talking about, on the lot that's behind Lot 2 that runs along the side of where that residential portion exists. The problem we're having, obviously, is it has nothing to do with our particular lot. We're in tune to invest almost $4.5 million in this project already, and it's just got to be astronomically expensive. And quite frankly, we don't see that as our responsibility. It's Dave Murdoch's responsibility, the guy who's developing Herriman Corners. And I think Dave should be required to put up the wall, as he committed to do in the first place. But I don't think it should be passed on to us in order to get our car wash open.
Thank you for your comment, Steve.
Sorry, I'm an applicant as well, part of that. In one of the notes that...
Can we save your comments? So are you part of the applicant? Yes. Okay, come on up. And will you state your name when you come up?
Yep. John Cloward, son of the guy who just said something.
Steve?
In the notes that the city sent us, they also gave us an option of creating a 6-foot privacy wall on the north side of that would basically be there until Murdoch decided to develop that back acre or back lots. Is that an option where we can put a 6-foot privacy fence, vinyl privacy fence, basically along our north side to block that residential from any visible or no noise that would be coming off of that side? If that makes sense. Instead of the concrete cast on Murdoch's lot, if we put the vinyl fence on the north side of our lot, if that's an option.
I appreciate your comments. Let us talk about it a little bit. Okay. But the real requirement originally from the developer is for the precast wall.
Yeah.
And so that's really what we're looking at this moment. Okay. I understand you're trying to mitigate it and make a temporary solution for while you guys are doing it.
Well, that was your suggestion, the city's suggestion to us. But Blake Thomas was the one who basically suggested it to us as an option to bring up. If we didn't want to do the precast, maybe that would be an option. But anyway.
Thank you for your recommendation.
Okay.
Or an idea. Do you want to touch on that?
I guess the only thing I really would say is that was, that's written as a staff recommendation, but essentially this is Planning Commission call.
Okay, thank you. Any other comments from the commission?
Go back a couple slides. Yeah, right here, actually. So are we talking about this lot, the lots to the west of this one? That's vacant commercial, right? Also.
We're primarily talking about the lots that occur north or are adjacent to the north of this, the highlighted lot.
So end of the end of the day, or eventually, or what we originally required the developer to do was to install, where was that precast wall? Can somebody tell me where that was supposed to go?
The precast wall was supposed to go so with the original subdivision, which had the 4 units that you can see that are already built,
Yeah,
and the KFC, the applicant that's come in, and all the other lots around here, the applicant at the time, with the subdivision application, was supposed to put the solid fence from the corner of the blue, that's the blue and green. If somebody could put their mouse where I'm trying to describe, it'd be helpful.
Somebody what? Where?
Can you put your mouse over it so we
Oh, let
can
me see what I got here.
describe?
Like right,
So go up to that corner to the right,
'cause
right there.
we're talking right here.
So it was from there all the way to the north, drive all the way up north, to the east, and then all the way to the north. That is what the original subdivision was supposed to do, with the exception, he went all the way to the subway. The subway was not part of the original application. So it was supposed to go to the subway property. And that needs to be done before we continue to build on these.
okay. And none of that is done, right? And there's not a precast wall on any of that?
Nope. There is not.
I do want to remind the commission that this is a conditional use, and the purpose or the reasons for conditions that you may attach to the conditional use is to mitigate potential negative impacts.
Yeah.
Regardless of the failure of a previous property owner, that doesn't negate the responsibility
requirement.
that you have to mitigate these
So
potential negative impacts.
our requirement is to put the fence along the entire thing, has always been that requirement, and we need to
My
need
concern.
to adhere it to start to happen.
Yeah,
Yeah, and to the developer, the applicant's point of view, we're just requiring the fence comes in. We're not saying who has to actually pay for
Yeah,
it. We're just saying
correct.
that's part of this
Pork and-
project. It has to be there. I mean, if that's your ultimate recommendation or decision.
Yep.
Yeah.
yeah, I just think if we continue to
change
build
1
these lots without having that detrimental effect mitigated, it just gets kicked down the
We're
road
just
further and further.
Passing
So,
it, and I agree with that.
Do you have anything else, Steve?
I can appreciate what the assistant city manager had to say. Here's the situation that we find ourselves in. We're willing to do anything that's on our property within our capacity to shield that residential area from light and from sound. That's why we're willing to put in that L-shaped fence in the back of our lot. That will, in fact, mitigate the sound issues, the visibility issues, and the light issues for the residents right there. If I'm forced to put that wall in, I have no recourse with Dave Murdoch. None. There's no agreement that I have with Dave Murdoch that he will pay for that. You're the only ones who have that ability and that authority to require him to put that wall up. And if he wants to build the rest of these lots and develop the rest of these lots, then he should be forced to do so. Unfortunately, it penalizes me. I can't build because I'm not building that wall. I can't afford the wall on top of everything else that I'm doing. It's not my responsibility. It's the developer's responsibility, Dave Murdoch. So I'm being punished for what he hasn't done, and I have no recourse on him.
Understand your frustration.
Thank you, Steve.
Mr. Chair, may I also add, when I made an earlier reference to mitigating those negative impacts, that does need to be on this property, right? To require off-site improvements, that's another issue. So, yeah, just be remembering what can we do to mitigate the negative impacts, but it has to be on his property that we're doing that. I see our city attorney in the back room. Do you have any, do you recommend, that should be appropriate, right? We're talking about mitigating impacts, but he can only control his own property, right?
Except for this was a subdivision application.
Right.
So we're not talking about, I understand where you're at, don't get me wrong. But this is part of a bigger subdivision that was created. So it does have some merit.
Yeah.
Any other
Am I wrong,
remarks?
City Attorney?
Any other remarks from Curtis, Andrea?
I kind of feel, well, the Ace Hardware will have the same issue. So if there's two landowner or two property owners now that are pushing to
Yeah.
get this wall done,
It should mitigate that issue.
then hopefully he'll just get it done, right? That's my thought, but.
It needs to be mitigated somehow.
And the one thing we need to do, guys, is we need to make sure we keep in mind that these are separate things, at least with the Ace Hardware and with the car wash, and that they're a little bit separate, and so let's make sure we keep them separate as we're doing it. I understand with the fence, and I think that's a valid point, though.
Well, so, and to Mike's point, and to the point of keeping them separate, if we really do that, and we are keeping it separate, and not looking at it as the whole subdivision, I get those issues, but there's that's a valid point. If we have to keep these separate and consider the conditional use separate from everything else happening in the subdivision on this property, I don't know that we can require I don't know that we can require the precast wall to be finished on another property because of, I don't think we can hold this one up, this conditional use up, because of stuff that needs to happen on other properties. I know we want to, but.
I don't know that that's not necessarily, I mean, the purpose of a conditional use is to put conditions on to mitigate the effects.
On that property.
Otherwise, it would be permitted use, and we would just be coming in and saying, okay. But it's not even that property. We have done conditional uses that mitigate traffic downstream due to a traffic study, correct, Jonathan? So
Caused by that property.
caused by that property, and this use is causing that commercial impact. Understand it's difficult, understand it's, but that's the,
I can see that one.
so.
I think you just need to make sure you tie your recommendation to a standard, if whatever it is you do. Yeah.
The only other way that I can see that we can mitigate this is to require a precast wall along their entire west end. That's the only way. A vinyl fence is not the same requirement as a precast. The only way.
They have a
I can-
precast already required on the west side of their property.
I'm talking the north side.
The north side, okay.
So yes, that's the only way I
Because
think
it's
that would be a fair requirement, unless, and maybe that's where we should say, is on the north property line, a 6-foot precast wall shall be required unless there is a precast wall along all of the residential. That mitigates the effect to me. It
What are the
puts
specific detrimental impacts that you're viewing?
our
from
protect,
the-
what are our
for-
requirements of commercial to residential. So if the applicant wants to go to the landowner and get the other piece solved, then there is no need for the precast wall,
Are the thoughts that it needs to be only a precast wall here
just along.
to mitigate it, or would a vinyl fence be sufficient for that, because it's between the two commercials?
Yeah,
Except for, it's not right now. It's not, that land isn't done. So yes, if the other project was here first, then I agree with you. But we have yet to ever require a commercial subdivision to do vinyl. It is always typically precast. And like I said, I'm comfortable with putting it in my motion that if the applicant can get the other property that's outside their control, precast wall, then that other requirement wouldn't be in place. And I think that's more of a fair, realistic expectation. That's just me.
Other thoughts?
so the detrimental impact specific to this property is the buffer between residential and commercial that you're trying to
Correct.
mitigate?
And once that's mitigated, then it's not an issue. And therefore, the wall would not need to be on this property.
How does a precast wall on the north property line mitigate a detrimental impact between commercial and residential?
Because you do have a piece of the property that touches that commercial. That residential is fairly close to that commercial.
I'd like to add one more thing too, just for you guys to consider. And Jonathan can speak a little bit to this, but in the staff recommendations, it said that they need a traffic impact study. There's different circumstances. Dave Murdoch, the applicant and developer of the entire Herriman corner, apparently has not yet done a traffic study for the entirety of Herriman corner, as was required.
So I have a question then, is how come if that has not happened, how did we allow a subdivision to occur?
I do not know the answer to that. But Jonathan may have something to add to that.
So what I just heard is that the master development, has not done a transportation study, which was the original condition on the subdivision. So my question is, how was this land subdivided then?
So that does bring up a good question. I guess it's kind of the same sort of impasse we're at here, where it was something that was required at the master development level, and we find ourselves with this lot saying, hey, a traffic impact study is required for this to happen. That was a requirement recommendation here from staff that we definitely pass along. It doesn't necessarily mean that he would have to pay for that study if he can work with that developer, understanding the difficulty of that, but nonetheless, that would be a requirement prior to this.
So even right now, even if we didn't, negating the fence completely, this applicant will have to do a traffic study for the entire development prior to advancing.
So that was a staff recommendation, but he would be specifically required to do that in the context of his lot. And so we've asked him, so for just that
For his
lot,
piece
his
of the pie.
piece.
So my question,
But the vision, I guess, would also have to include the entrance, a little bit of 134th into the lot. When we've talked about the area, what that would require. But sorry, continue.
so again, my question and my confusion is, are these legal lots that were legally subdivided by the city? That's a yes or no question.
Yes.
Then how come those requirements have not been enforced prior to or bonded for? That's kind of what I'm trying to get at.
And that's what we're looking into right now to see if we've bonded for that particular portion of the fence real quick.
Okay.
But to answer your question right off the bat, Adam, I couldn't answer that right away on, the particulars of how that transpired.
Okay, that's fine.
Anything else from Planning Commission? It looks like the applicant has one more thing.
I'm sorry, I just, we haven't done a lot of developments, but we've done a few. And I've just never been held responsible for something that somebody else didn't do. And that's what I'm looking at here in this particular case. Dave Murdoch was required to do that traffic study, and he didn't. Dave Murdoch was required to put in that concrete fence, and he didn't. So instead, because I come along and I'm willing to put out a sizable amount of money that we've accumulated to try and put in a new car wash and a quick lube into Herriman, which I think will be a great business for you, and I hope a great business for me. But in order to do that, I have to make right all of Dave Murdoch's shortcomings.
Understand the
I just don't think it's
frustration.
fair, and I don't think it's right. If you could go to me, I'm willing to pay. I told the city I was more than happy to do an adjustment or a draft memo to the traffic study and have them look at our portion with the KFC and see how that will fare out. Absolutely fair request. Problem was, when I got to looking into doing the draft, I couldn't do a draft because there was never a traffic study done in the first place. And this was only going to be a review and an addition to it. So all I'm saying is, Dave Murdoch's, even right now, talking about selling 2 more of these lots. Yep. Why isn't he understanding the fact? How was he allowed to move forward and sell as many as he did already without meeting that requirement?
Your question and my question are one and the same.
But why penalize me because you allowed something to happen with the development of these other lots that I had nothing to do with, but I've got to correct it?
We appreciate and we understand your concerns. Let us see if we can talk through this and
One
figure
last
this out.
issue, and just a question for you, okay? If I agreed to cover the cost of a traffic study, and I agreed to put in a wall, rather than putting in a wall along my north side or west side, I'd rather put a wall down behind where he was gonna put Tractor Supply, which is, you know, along that lot that's next to me, provided I could get the city to require Dave Murdoch to reimburse us before he could sell another lot.